Welcome to Family Law Talk, presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a family law firm in the St. Louis metro area with offices in Missouri and Illinois. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. My name's Kirk Stange, managing partner of Stange Law Firm. Today I'm on the phone with Keith Law. And Keith, you on the phone with me today?
I am indeed, Kirk.
All right, well, great. Today we're going to be talking about winning cases in the social media age. But before we begin the topic, I should state that the choice of a lawyer is an important decision that should not be based solely upon advertisements, and that the information that you obtained from this podcast today are general in nature and may not apply to specific factual or legal circumstance. Now on to the topic here today. Again, winning cases in the social media age. Keith, tell us, talk about the topic and tell us a little bit about what we should know.
Well, thank you very much, Kirk. I might start by just giving your listeners and yourself actually a little background about what I do and kind of the perspective that I bring to the subject. I'm a research journalist, and I'm especially fortunate to be assigned coverage of stories and subjects that are very high profile and some of the most important stories and subjects of the day. And more and more, those assignments are leading me towards social media and the law. And so that's how I kind of have developed an interest and experience and some knowledge of how social media is impacting the law. And, of course, I bring a journalist's perspective to the story, which is to the subject, I should say, which is quite different than your own or lawyers in general. And, for example, I was, like everyone else, covering the Casey Anthony trial as a observer. It was a trial based in Florida that involved a woman that was charged with killing her 2-year-old daughter, and that became what Time magazine called the social media trial of the century. And I was asked by the editor at Harvard, who was the former Watergate editor for Woodward and Bernstein, to write an article on how social media was impacting that trial. And so that was kind of a kickoff for me, and since then I've been engaged in these kind of the confluence of social media and the law. And what I find interesting is that many lawyers are averse to using social media in their practice, and on behalf of their clients, in some cases, some attorneys are actually afraid of social media and view it as an intrusive institution or an intrusive phenomenon of our current age. And I have to say, from my perspective as a non-lawyer, but just as an observer, that I think that they put their clients and the people they represent at a distinct disadvantage in representing them before the law.
Why is it that some attorneys, Keith, do you find that they're kind of afraid of social media?
Well, I think there's a kind of a mindset that is not peculiar to attorneys. It's kind of a human condition of resisting change, and some people resist change, others embrace it. And I've talked to lawyers and heard lawyers discuss social media and how they want to use them in their practice quite a lot. And I find a distinct divide where a lot of attorneys feel that social media and what is going on in social media is a threat to the justice system itself, and they view it that way, and they try to exclude social media as a kind of a strategy in their own practice. And for example, I've heard attorneys say that, well, I'm really not interested in what anybody thinks about my case or about my client or about my opponent out in social media. All I care about is what is available to me by the rules of evidence and through the rules of discovery and depositions. And social media is a distraction. And they practice their law on that basis. And
it's interesting
whereas
you use the term threat. That term threat, I just, if I could follow up on that a little bit, I'm sorry to interrupt you, but you said they view it as a threat, social media and looking at social media. What do you mean by that? I mean, it would seem to me like it would be just a bunch of information available that might be really helpful to their case. I'm curious why some attorneys view social media as a threat.
Well, of course, you sound like what is called an early adopter. And for those that aren't familiar with the term, it doesn't refer to adopting children. It refers to embracing and using and utilizing current social media and internet resources as they become available, as new resources are on the market, whether it be iPads or all kinds of smartphones and so forth and so on, all the apps that are available. Attorneys that are early adopters are looking for ways to use them and leverage them on behalf of their client, whereas others look at the social media world and they are very much aware that the American Bar Association and the profession itself is somewhat struggling to keep up with the changes that are going on in social media in terms of ethics, in terms of rules of behavior. For example, there are serious issues of spoliation of evidence that an attorney can get himself involved with if he's not current on social media itself and on what the rules and ethics involved in an attorney's use and interaction with social media are. For example,
what is spoliation for the listeners? What is spoliation? Because a lot of people might not know what that term means precisely.
Could I kind of turn the question around, and I think you would be the person to really define that as a lawyer.
No, absolutely. I mean, what I'm trying to do is just kind of define that term, from your vantage point for the listeners out there, and when you use that term, and what are you referring to in the use of that term, spoliation? Sure.
Yeah. For example, if an attorney is representing a person or a client that involves divorce, and he or somebody on the staff is perusing or searching through social media like Facebook, and they see let's say a friend of their client or a friend of the opponent on Facebook, and that attorney then interacts on Facebook with that person for the purpose of trying to generate information that he can use on behalf of his client without identifying himself and as somebody who's representing this person in this case. That definitely would introduce issues of spoliation of that evidence in a settlement, a pretrial settlement, or if we got to trial, of course, obviously there. So those are issues that an attorney that embraces social media and stays current with the American Bar Association and the State Bar Association rules and guidelines on how to interact and use social media is familiar with. And instead of fearing it, he just obeys those rules of the road, so to speak, and therefore is able to use social media, for example, Facebook and Twitter and so forth, as a resource on behalf of his client. Whereas the person that sees social media as a threat, that concern and that kind of perspective of social media is just reinforced by these fears. And as a result, his client is underrepresented.
Right, absolutely. And Keith, what is e-discovery? I know that obviously in family law cases or really any litigation, there's a discovery process. But can you explain to the listeners what e-discovery is and how that can be a key resource for successfully representing a client?
Well, that is, we could spend probably 6 shows just talking about e-discovery and ESI, which is electronically stored information, the cloud, which is a resource for storing information, external hard drives, all of that, and even your smartphone. I might mention the Supreme Court is going to be expected anyway to hear a case next year on the right of police to investigate the computers that we all carry in our pockets called smartphones without a court order or a warrant. So that if they stop somebody and they have a smartphone, they want to be able to look at the files on that smartphone. They want to be able to look at the emails, the texts, and so forth without any court order or warrant. And the Supreme Court is going to be deciding that issue, I believe, next year. So that is just, and of course, e-discovery is an extension of that very process. What e-discovery is a discovery process for evidence that an attorney uses on behalf of his client. And in the case of e-discovery, it's looking through any electronically created information. And that could be, for example, files on a computer. That could be the record of you or me or anybody on Facebook, or your Twitters, your tweets. That would be available through e-discovery. And of course, in Facebook, there are people that create what are called secret or private Facebook pages. Those are available through e-discovery, even though they're secret. And if you Google search for information on a secret Facebook page, Google does not come up with any search results, but they're there. And you can require and ask for the password and username for a Facebook account. Usually in a letter of introduction, as you begin a case, that should be the first thing a lawyer does, is make that request through e-discovery and look for every source available, conceivable, that can help his client through e-discovery.
Specifically in regard to family law cases, how can e-discovery assist clients, for example, who are going through maybe a divorce, a child custody case of some time, maybe a child support case, or just really any family law case in general?
Sure. Well, I mean, the record is just full of anecdotes and instances from divorce case records and family law histories of just that kind of thing. For example, in a divorce case, for example, let's say an attorney is representing the wife, and let's say that she has been and incidentally, as a journalist, quite often I get introduced into social media, the confluence of social media and the law, by kind of personal stories. I'll be looking at or writing about somebody that on my particular subject, and it turns out she gets into a divorce proceeding, and then a story develops from there. And that kind of brings me into social media and the law from that point. And I've covered and am aware of many stories where a wife has been, let's say, had the wool put over her eyes by her husband in terms of his relationships with other women, his relationships with money, and so forth and so on, that the wife is simply not aware of. And then when he files for divorce, or she does, all of a sudden she may be finding these things out from friends who knew her husband but would not tell her because she was married to him. And as soon as the divorce proceeding and filing gets public, and she tells her friends that, all of a sudden from Facebook, from Twitter, friends of hers and of her husband's will tell her things that they have found her husband saying and involved with on social media sites. For example, he may be showing photos of himself with other women in places that she didn't know that he was at, and all of a sudden this can impact materially the whole outcome of their situation. And of course, from my standpoint, people that come to the law and they come to a lawyer for representation, basically they do that because in a lot of cases they aren't able to resolve a situation fairly and justly between the parties themselves. So they rely on the law to produce a sort of justice in that circumstance that they're in. And it's very important that an attorney have as much information on behalf of his client to support his client, so that she, in this case, can get as much equitable result from this proceeding as she deserves and is rightly in her interest.
Yeah, absolutely. And in terms of child custody cases, would you agree with me that information obtained on social media sites can oftentimes be very valuable in determining what's in the best interest of a child?
Well, certainly, and I'm sure you're aware of, from your colleagues, and I'm certainly aware of situations where there's often child custody issues are very emotional. They're very, they can be very antagonistic sometimes, and it's very important that in the interest of a child in those situations, that all of the information about the two parties be brought up to the surface so an equitable resolution can be made. If you don't know everything about the two people, it's possible that someone could have an unfair advantage as a result in deciding child custody cases. And here you have a child that's very much at risk in those circumstances of going with the wrong parent or not getting enough visitation or too much visitation, and that could impact that child for the rest of their life. So if an attorney will look for social media and find out, for example, that a child who is currently in the custody of one of the parties to a divorce and child custody dispute is allowing the child to go on Facebook and have friends or tweets and so forth and so on at 2 o'clock in the morning, or and is creating and joining groups in Facebook and so forth that a responsible parent would not allow and would oversee, that information needs to be brought up to the surface on behalf of the other custodial parent, so that fairness is a result of the proceeding.
Yeah, absolutely. And then in terms of family law cases, pretrial conferences or settlement conferences, kind of synonymous terms based on, at least in Missouri, and in terms of what courthouse we're at. Sometimes they call them pretrial conferences, sometimes they call them settlement conferences. But it can often be very advantageous when you're going into that pretrial conference or settlement conference, and you've got that social media, evidence beforehand going into that settlement conference. I mean I can imagine that brings. Yeah, I mean that's just. To me, it's infinitely valuable because oftentimes, unlike a jury trial situation, the judge that's hearing the case is the same judge presiding over that pretrial or settlement conference, and so, getting that information in front of a judge in advance definitely helpful.
Well, and also not just in child custody, but in child support. There are many instances where one of the parties, let's say the defendant, is understating income, and the plaintiff's attorney was able to uncover from Facebook or social media showing the defendant with a lavish lifestyle and expensive boats and so forth, where they are actually understating their income and resources. And those pictures alone, and of course I'm sure you know that graphics and pictures are powerful pieces of evidence in any relationship or in any conversation or discussion, but in a legal case especially. And the many situations where just the pictures of somebody in a lavish lifestyle understating their income and resources in terms of how they're going to pay child support, it just turns everything around, and the child and the in this case the plaintiff benefit appropriately from an attorney who is able to gather that information, and instead of leaving it on the internet where it doesn't do his client any good, he brings it to the settlement table, to the pre-settlement or pre-trial conference, as you're saying, and where it can be used appropriately on behalf of his client.
Yeah, absolutely. I think the other time to use that information, depositions in family law cases, it can be infinitely valuable as well, because you could show, for example, those pictures of the expensive boats or the vacations or the weddings. I mean, you could show that to the other party in a deposition and ask them to explain, what's in that picture. And that oftentimes, I think, useful. I mean, I think it could cause the other party to all of a sudden become more reasonable. Certainly, though, it allows you to get information and opens a door to information that you wouldn't be able to get otherwise. And I think Facebook, some of these sites, interesting because I mean, it seems to me a lot of people will paint their life in the most positive way possible on a lot of social networking sites. Like it's kind of I don't know, it's kind of showboating or bragging. It seems like it's a great time for people to want to do that, which of course, in a family law case, when you're dealing with child support and spousal support, that can be quite damaging when you do that.
I can imagine, and from a journalist perspective, it's interesting to me that in my own part of my own research, I've read where Justice Oliver Wendell Holmes, going over 100 years ago, defines the life of the law as experience. And, of course, I can relate that to contemporary days as somebody who is living in the information age and the age of the Internet and the age of social media is very much a major and influential component of current experience, and that is information technology and social media and so forth and so on. And so for an attorney not to understand that is really somebody who's kind of fighting reality and the current environment that they're living in. I'm used to kind of phrasing things in journalistic terms, and one phrase I like is that social media is the ocean that lawyers swim in. And from my experience, that is very much the case. And in order to navigate and negotiate through that ocean of social media, you really need to be able to swim. And that means knowing what social media is out there, what the resources are available, so that you can represent your client in the best and strongest possible way.
Yeah, no, and I absolutely agree. And obviously, I just think social media is key and vital. I think a lot of firms out there are still, in all frankness, you see them in the phone book a lot, or you see them advertising on like maybe radio or TV or other areas. And oftentimes, it's not 100% the case. Obviously, there's exceptions to the rule, but I would just state, I don't know, as a research journalist, if you'd agree with me or not, but it would seem to me oftentimes you can kind of judge whether a firm is an early adopter of social media by that law firm's online presence in and of themselves. Firms that are normally savvy from an internet perspective, those are oftentimes, not always, but oftentimes the firms that they're going to be very good in terms of looking at social media evidence in cases. It just seems like it's kind of a spillover effect.
Well, it's interesting. It's the attorneys that are not early adopters, that are not embracing social media, are being dragged into it, even as they're kicking and screaming against it. But it's like everything else. There are, in that process, the people at the lead are the people that are most successful, and those are the people that are not fighting, the change, and they're embracing change. And the American Academy of Matrimonial Lawyers, for instance, says 80% of its members have used or have faced evidence gathered from social media in their practice. And so, to me, that says it all, especially for family law attorneys. Yeah,
absolutely. With smartphones, as you referenced, and iPads, and then you've got laptops. There's just so many ways individuals get online these days that, really, I know there's some individuals out there that probably just never get on the internet, and but I think even more and more you see that becoming a slimmer and slimmer minority, and I think most people in some manner or form, find themselves online, and that leads to obviously evidence in cases where it leads to a family law case or custody dispute or whatnot. we touched on this a little bit, but in terms of character evidence, what type of character evidence can you get from social media?
Well, that is, social media is relatively new, but it's very ubiquitous. Facebook started in 2004. It's hard to believe, but today has over 1 billion users, and Twitter has 200 million users, and LinkedIn, one of my favorites, has 80 million. And it's interesting in my own research that I've discovered that as time goes on, already summons have been served via Facebook. Judges have allowed summons to be served via Facebook, and also injunctions and various processes have been served via Twitter. And of course, to me, that is a tremendous salient point for somebody in the legal profession to understand that how much their profession is changing from the days of hiring an off-duty policeman or a state trooper or somebody to go around serving summons and whatever and processes and so forth. You're now doing it on the internet, and
that's a pretty amazing point. You can actually serve somebody through their Facebook account, like a summons.
Yeah, absolutely. It's been done, and it's only going to increase. And Twitter as well. Twitter is kind of it's about 1/5 of the size of Facebook, but it's kind of overlooked by a lot of people. I use it a lot, and but injunctions and processes are being served on Twitter or with Twitter. And
that's amazing.
And and the value of that is, of course, it's much cheaper for the client. It's in terms of time with the attorney and paperwork and all this stuff. It's just more efficient, and it's better for the client and better for the firm to be that efficient on their behalf.
That'd be huge at our firm, and we have a lot of cases where it's an international case where maybe one parent is living in the United States and somebody else is overseas. At our firm we have a lot of clients who are in the military, for example, and because of that, there can be international components to these cases. But that would be huge, because that's one of the biggest, I think, dilemmas we have now going in our firm is with these international cases. You're trying to serve somebody in a foreign country or territory, and that's extremely difficult. And wow, if you could serve somebody through Facebook or Twitter, boy, that'd sure make it a heck of a lot easier in a lot of these cases. And I mean, if somebody's checking that account and they're logging into their Facebook and Twitter account and they're in there regularly, why not? I mean, that would seem to me that's a lot better than what we have to do now when we can't serve somebody. We post in these old legal periodicals that nobody reads. You publish notice.
That's right. Yeah.
Nobody reads that. So serving them through Facebook or Twitter would be. I mean, it would seem to be a fair way to do it, and wow, it would really help the clients out. I mean, in terms of the cost and moving cases forward. That'd be a pretty incredible development if we could do that here in Missouri. Hopefully we get to that point.
I'm sure you will, and no doubt about it. And also Skype in terms of depositions overseas or in other states and so forth, or even in situations of if they're in a nursing home or some situation like that where Skype can be used and recorded for depositions or other purposes, taking statements. That's available.
We do that meeting with potential clients now. We do Skype with clients overseas. So, we've been doing that for a while. I mean, that's a great tool. But you're right. If you could do a deposition via Skype, because that'd be tremendously better than doing a phone deposition, for example, where you can't look that witness in the eyes and you can't judge facial expressions and you can't see if they're looking at some paperwork while they're answering their questions. So a deposition. Well, I can tell you, as attorneys, we're always leery of phone depositions. I know I am. I mean, there's nothing like looking a witness in the eyes and just kind of seeing their facial expressions and their mannerisms but sometimes it's not really worth it to the client for me to fly out of state somewhere and charge them for that. So if you could do depos versus Skype, that'd be a phenomenal development.
And one thing I should mention, since we're talking about social media and also on the video depositions, YouTube gets 2 billion views a day. And that's one of the video resources that is available that we've been discussing. Also, of course, the information about somebody that you can get on YouTube sometimes is mind-boggling. And there's nothing more persuasive than a YouTube video of somebody, let's say, in a situation that contradicts his own self-definition or her own self-definition, or how she's representing herself, or he is, and you see this YouTube video. Nothing is more persuasive and important, in a legal proceeding. And so YouTube is another resource that an early adopter of social media, and YouTube is a social media resource, can leverage on behalf of his or her client and benefit them very, very substantially.
Yeah, absolutely. I mean, it's so easy to make videos these days. I mean, if you're walking around with your iPhone, you can, most iPhones, you can just record videos and right there from that phone upload it to YouTube. So yeah, we've had that happen in situations where maybe one person or another's out partying and they think, after a few beverages, it'd be a fantastic idea to put that on YouTube. Of course, it's not a fantastic idea at all. But yeah, absolutely. YouTube, you can definitely get a lot of information. Because it's just so easy. I mean, any laptop computer these days too. I mean, most of them have a camera on them, and you'll see people just shooting videos right there from their laptop. And
there's something about something that I can add as from my perspective is that there is something about Facebook, about emailing and texting and chat rooms and blogs that reduces the self-discipline of a person sometimes in terms of what they say or what they suggest or what they how they are recorded on video, that may very often contradict something that they have given by deposition about themselves or about some fact. And so it's very important as an attorney, I believe, to make available and to expose your client to the benefits of social media by looking at the record out there of an opposing person or a witness or an expert, whoever it might be, by their own word, by their own hand. And it's amazing what you'll find. You do a search for somebody, and you find out they're on Facebook or Twitter. You can get their history of tweets. You can get their chats and emails on social media. It's amazing what people will say that very often contradicts what they have given in deposition or in testimony or in statement. And if you have,
absolutely.
I was just going to say, if it's left out there on the internet, it's not of any use to your client. And so that's where an attorney who's...
Yeah, absolutely. LinkedIn, one of the things I like about LinkedIn, for example, and when you get into child support cases, I mean, LinkedIn's like getting a copy of somebody's resume in a lot of ways. You can go right on somebody's LinkedIn page and, you can see where they've worked and what their job history is. And, some people even post amazing things like their salary history on there. A lot of people, I think on LinkedIn now, you can just simply upload, the exact resume itself, and you can put that right on a LinkedIn page. Where in the past, you'd have to send a request for production to somebody, and they'd have 30 days to respond in Missouri. You'd have to wait on that, right on the resume that way. But now people are just posting that stuff right online. And yeah, exactly what you said. I've had individuals who claim they weren't making a whole lot of money, that they're hurting financially. Then you go to their LinkedIn page and they're bragging about how much money they're making. So definitely, I've got multiple cases where that's been the case in particular, where they're crying poor and they act like they're just doing terrible, and then you go on the LinkedIn page and it's they're generating substantial money and business is good, and lo and behold, it's a totally different story.
And the nice thing about it, it's all by their own hand, in effect. It's what they post themselves about themselves.
Yeah.
Or
they put it up there.
Yeah, and if they join a group, it's by their choice and by their decision, and so forth and so on. One thing that I've experienced in doing research for high-profile trials, and also occasionally I write and research for prominent trial consultants, is the use of cell phones as a resource for gathering evidence, basically. And there is a software product called Celebrate, which will take, and you can request as part of e-discovery that somebody, for any reason that's approved by the court, turn over their cell phone. And from that cell phone record, you can get not only text, emails, and files, but you can also get the location and travels of that person over a period of time or a specific day. And they will tell you within a reasonable location, based on cell tower locations, where that person was at any given time of any particular day. So if somebody says, well, and this quite often is the case in matters of dispute in the law, well, I was at work, on a certain day. I couldn't possibly have been meeting this woman at a bar. And you just get his cell phone information and use this software, which is very inexpensive, and you just get a printout of his location on the date and in that time frame, and there he is. He's at a bar or near a bar. And so it's just interesting as somebody that is basically just observing as a journalist, these resources from the internet, how important they are to attorneys.
Now, you said in this Casey Anthony trial, I mean, you're writing a book, right? Correct, on the Casey Anthony trial.
Yes, I've been commissioned to write the definitive book on the Casey Anthony trial, and it's been an education for me how a person like myself, as a journalist, can start with the one-sided narrative of that case and just do research and just let the facts write the story, and how you can change your own, or a person can change their own perspective at the end of that road. And so it's a journey for me as well as for the readers of my book when it's published later this year.
Now, obviously, that trial, criminal law situation, different than family law, but still, when you're talking about social media and the law, obviously, the way social media impacted that case could have certainly a spillover effect into family law. But I'm just, obviously, the book hasn't come out yet, so you're still writing it. But you said it was the social media trial, I think, of the century. Is that right? I'm just kind of curious, in a general sense, how was social media so relevant in that case? If you give us a sneak preview.
Well, yeah. Sure. Time magazine labeled it that, and of course, I assume that most people at least heard of the name. She was a young woman whose child died, and for months and months she denied that the child died, and made up stories about why the child wasn't with her anymore, and she went out. She was photographed in nightclubs during this time, and turned out that her child had died, and her own mother arrested her for this crime, and she was facing the death penalty, and the trial became the social media trial of the century. She was voted the most hated woman in America for 2 years running, 2011 and 2012. Interesting that as part of my research, social media became so important. HLN, which is a cable network that covers trials, usually high-profile criminal trials, but that became a driver of public sentiment, along with the blogosphere and social media and blogs and YouTube, for defining that case and forming people's opinions about it. And what's curious about that particular case, and it really does apply to family law where you have bench trials, the jury came to a completely opposite opinion from the court of public opinion and social media. And it wasn't a close call for the jury. And so that is a huge opportunity for somebody like myself as a research journalist to look at social media and to examine it and to come up with some reasonable conclusions about the nature of social media. in working with a trial consultant, there's something called that she uses called social media analytics, and she can use. She has software programs and huge resources to take what is said on the internet about any particular subject. It does not have to be a high-profile subject. It can be family law. She works in family law quite a lot, and to advise attorneys and their clients on how to present their case, evidence, and so forth and so on, graphic media to be used in the presentation, even in pretrial settlement discussions. Just as important there as it is in a bench trial. And so in the Casey Anthony case, it turns out that computer searches for chloroform and foolproof suffocation played huge roles in that case and in how people perceive that case, and also her whereabouts via her cell phone analysis were critical in that case. So kind of the whole panoply of the social media world is wrapped up in that case, and I'm very much looking forward to the publication of the book, which, by the way, concludes that the jury was right.
It concludes that the jury was right. That's the conclusion that that you came to?
Yes. Startling.
Yeah.
And
startling?
Startling, yes.
And okay, all right. Well, we obviously we'll wait for the book, but and read how you came to your conclusions there. But obviously, that was a really interesting trial that obviously captivated, I think, captivated everybody, even being non-family law. Obviously, court on TV is kind of thing that can get you wrapped into it. Definitely the case. Now, in terms of trial consultants, you said you've worked with trial consultants. Is that right?
Yes, I research and write for Dr. Amy Singer from time to time. She was the trial consultant for O.J. Simpson, Michael Jackson, William Kennedy Smith, and Casey Anthony, and Jack Kevorkian. She's the preeminent trial consultant in the country, she defines what an early adopter is, and she is she's leading social media analytics for in its use of in the law, and she's a very remarkable and very successful woman. She's a PhD psychologist.
No, go ahead.
No, I was going to say she's got a PhD in psychology, and that plays some component, a useful component in the work she does. But she uses social media analytics extensively to help attorneys evaluate their case. And as I say, it does not have to be a high-profile case. It just as effectively applies and is used for family law, for motorcycle accidents, DUI, and so forth.
So, in other words, what she would do is help, in trial consultants in general, is help analyze how a case is presented to ensure that it's presented in the best possible manner to the court. Is that kind of a fair assessment of it?
Well, yeah, in a family law case, because it's bench trial, and because, as you said in the past, that maybe 80% of the family law cases typically are decided without a bench trial or prior to a bench hearing. That what she would do, and what legal consultants would do who use social media analytics, would be a lot of what they would do was to gather information on behalf of the attorney to use to support their client in kind of the ways we've been discussing. She knows, where the bones are buried, and she knows how to get at them, and she knows how the attorney can request, the appropriate documents from the court to make that happen. And she knows, for example, that you can issue a summons through Facebook. She knows that you can issue a process or other things through Twitter. And these are just ways that just make things a lot easier and more effective and more efficient for an attorney in a pretrial or a settlement issue with their client.
Yeah, absolutely. Now, and I think in kind of chat with you before we went on the air, you talked about that social media can even be used, for example, to help maybe get inside the mind of the judge in terms of the way a judge might view a case or a particular situation as well. Well,
that is, that to me is I don't know why, but it's the most interesting. When I just as a layman think of a bench trial, I'm thinking, that's his domain. That trial court is his domain. He makes the rules. His word is law in effect, unless it's appealed. And it's pretty difficult for an attorney to leverage resources that an attorney brings in that environment. But what I'm finding out is that that's not the case. And for example, in the trial that I talked about, the social media trial of the century, the original judge was contacting a blogger who was urging that the defendant pretrial be hanged, and that she was no doubt guilty. So the trial judge was calling that blogger and encouraging the blogger to continue on with that point of view. And he was the trial judge. And the defense attorneys found out about it and had him thrown off the case. So, I mean, that kind of thing goes on where judges are like everybody else. They have biases. In family law situations, they're not as egregious as the one I just mentioned, but they can have biases about a profession that a client may be in, or a circumstance that a person may be in. They may have biases that affect their decision. So what you can do with social media is expose all of that and be aware of it and then address it. And there's a couple of formats. There's something called Judgepedia, and then there's something called Road Probe that an attorney can utilize very inexpensively. And these resources will give you a very thorough evaluation of that judge, a record, his statements, his friends, anything that would be of interest to an attorney presenting a case in front of that judge. And they very extensively use social media, surprisingly. And it's kind of surprising what some judges will post on social media that can be used by an attorney in his court.
Wow,
for example,
that's interesting.
Yeah, well, I mean, judges are permitted by the ABA to participate in social media. And so they may join chat rooms or groups. They may become members of an advocacy-oriented group on Facebook or somewhere else. They may have commented about a company or a profession. And then your client may be a member of that company or that profession. And who knows, that might be an appeal issue. That might be something where you get a judge removed. But in any event, the whole, from my perspective, the whole value of this is to bring as much information up to the surface as you possibly can so that you give your client a level playing field. Without that kind of information, your client can be really, really in a difficult situation through no fault of your own or no fault of her own, but through the bias of the sitting judge. And the judge may not even identify his predisposed feelings as biases. He may be very comfortable with them, but somebody else may see them as a bias. And so that's the value of social media from my perspective.
Yeah, absolutely. I mean, obviously, I have a great deal of respect for the judiciary, and obviously family court judges, boy, they've got a heck of a hard job to do. It's one of the hardest jobs out there because not only do you have to enforce the rules in the courtroom and the rules of evidence, you actually have to decide the case, unlike a criminal case where the jury ultimately makes the call on it. So family court judges, obviously, I think they have one of the hardest jobs out there that a judge could possibly have. But obviously, like you say, judges are human beings just like everybody else, just like you and I, and we all have different viewpoints and associations and whatnot. And there's no question that on some level that can just kind of change the lens in which we view the world, or maybe a particular case.
Well, and also, the judicial system is an advocacy system, and it really depends on an attorney, in my opinion, being a strong, professional, and aggressive advocate on behalf of their client. And so that, for example, one of the things that to me is a useful resource is there's a group called Roving Room, and lawyers anonymously provide information about judges that they've practiced in front of. Well, from my perspective, that's attractive because it's an anonymous source. But I would take that into consideration, the fact that these statements are made anonymously. But the information that they provide does open up avenues to look at on behalf of a judge that you would never consider if you didn't have somebody who had practiced in front of them just saying, well, here's what I found about this judge. And as I say, to me, it's all good, because it's information that is brought up to the surface and where it can be used and evaluated. Some of it's going to be thrown out, some of it's going to be counterproductive, but that's what the practice of law is all about. And the worst thing in the world for a person who's relying on the law for justice is to be represented by an attorney who leaves all of that kind of information untouched, unreviewed, unknown. Because among that accumulation of information is, in my opinion, the piece of information that can make all the difference to a client. And that's why, at the end of the day, if I have an attorney that is comfortable with social media and then uses it aggressively, that's the attorney that I want.
Yeah, absolutely. And I think it can save clients a lot of money, too, because, if some of this information can be obtained online, that can be a lot less expensive than, sending interrogatories or requests for production out to try to get the information. It's also, can be a lot more accurate, too, because, you send requests for productions out and opposing parties conveniently, they say they don't have the documents in their control anymore. You ask them an interrogatory and then, boy, they don't recall, an answer to a question in terms of what happened on maybe a particular evening or about a particular fact. But right, I just think you save your client so much money too if you're able to, to ethically and according with the rules of professional conduct get information online. It just definitely invaluable. I think definitely gives clients a leg up in a lot of different ways. It's totally true.
Yeah,
totally true.
And the person who hires an attorney is very much dependent on the professionalism and the quality of the representation that the attorney they hired offers them. They really are depending on their attorney to represent them well. And one of the ways an attorney does that, in my opinion, is to turn over everything available from social media and the internet on behalf of their client. And I really am sorry for the client that hires an attorney that does not use that as a resource.
You even talked about including social media in engagement letters to clients. Is that right?
Oh yeah, definitely. That's what should be one of the first things that an attorney includes. That they want information that's part of e-discovery from social media resources. They don't want anything destroyed. They will state that in letter of engagement. They don't want any accounts deleted. All of that, you can form it in legal terms and appropriately and comprehensively. But in a nutshell, that is like that's like step one, and it's just kind of the e-discovery 101 for an attorney these days.
And I bet most attorneys don't. They're probably not even thinking about that when they're doing an engagement letter and intake sheet with a client. I would bet that's probably pretty rare, even though, like you say, something that attorneys should definitely do right out of the gates. Well, very interesting discussion. Keith, anything else you'd like to add that we haven't discussed?
No, I think it's been a pleasure on my part to talking with you, and also I've gained a lot of insight from hearing your perspective and reaction to some of the things I've said, and I appreciate that very much.
Yeah, well, Keith, it's been our privilege and honor to have you on the show here today. Definitely, this information definitely going to be something that our Internet listeners are going to be interested in listening at our firm. You know, we've got a lot of clientele that is online and actively engaged in social media, so I'm sure they'll find this whole discussion fascinating. So I want to thank you for coming on the show. Definitely our privilege and honor. And we look forward to your book coming out, and on the Casey Anthony trial. Look forward to reading to that. And again, thank you for coming on the phone with me today, Keith.
It's a pleasure, and anybody that wants to read anything, they can go to writerkeith.com, and I'll be right there.
Outstanding. Well, Keith, thanks again for coming on the phone with me today. This will conclude our episode today of Family Law Talk with Stange Law Firm. Tune in next week for our next episode. Thank you very much, everybody.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic, or to put Stange Law Firm to work for your family today.
Go Ford for your next truck or SUV and find an easier way to buy with Woodhouse Ford today, and experience the convenience of buying with Woodhouse Ford. Save up to $13,000 off MSRP on a 2023 Ford F-150 XLT, plus 3.9% APR for 60 months with approved credit. $299 doc fee due at signing. Security deposit waived. Expires 1/02/2024.
With the Lucky Land Slots, you can get lucky just about anywhere.
This is your captain speaking. We've got clear runway and the weather's fine, but we're just going to circle up here a while and get lucky. No, nothing like that. It's just these cash prizes add up quick. So I suggest you sit back, keep your tray table upright, and start getting lucky.
Play for free at LuckyLandSlots.com. Are you feeling lucky? No purchase necessary. Void where prohibited by law. 18+ terms and conditions apply. See website for details.